And welcome back to Capitol Tonight. Scaffold law reform has been a perennial issue in Albany, and while past efforts to ditch the century-old law have failed, this year could be different. I feel like I say that every year. The Lawsuit Reform Alliance says that more than half of the state's county legislatures have at this point passed resolutions calling on state government to act on the scaffold law. Joining me now in the studio is Tom Stebbins. He is from that organization. You recognize him. He's been here before. Thank you so much.
Great to be back.
Let us first open by reminding people what is the scaffold law.
Sure. Well, the most important thing to know about the scaffold law is that it doesn't necessarily have to do with scaffolds. What it does is it applies absolute liability to contractors and property owners, and in the words of the court, even if they had nothing to do with the plaintiff's accident. So if there's an accident on the job and it's gravity related, 99.9% of the time, it's the contractor or property owner's fault.
Okay.
The reform we're looking for is that we go to court, just like we would in every other state, just like we would in every other aspect of the civil justice system, and apportion liability based on the facts.
So, okay, so it's been how many years have you been looking for this to change now?
Well, the law has been around since the 1880s,
Right.
and most states got rid of it when they installed the workers' comp system. New York didn't. The last state to have it was Illinois, and now New York is actually the last of the last.
So did New York not do it because of the strength of labor here? Is that why?
I think it wasn't really the absolute liability standard, interestingly, is not written in the law. It was the way that the courts have interpreted it that have implied that absolute liability. And that's the real problem. We're not looking to change the safety provisions of the law. We're looking to give the court more direction to say, none of this absolves the plaintiff of their own action.
But, and I know we're sort of not getting to the point, we'll get there, but I guess I don't understand why, I mean, if it's not written in the law, all you really need is one judge to make a decision, right? I mean, isn't
that's not the way case law works. I mean, once you have case law from the
You've established
1940s
a
and then it's
precedent,
re-established in the 50s and the 60s and 70s, and there's hundreds of cases now that have imposed this absolute liability. And again, no other state does it this way. So we feel that it wasn't the original legislative intent, and so we need to give the court direction to say that no, it's not absolute liability. Let's go to court, let's look at the facts, and let's apportion liability proportional to fault.
Okay, but just theoretically speaking, could a judge look back at the original intent of the legislation and overturn all those years of precedent if he or she so desired?
I wouldn't expect it in New York. You'd have to talk to a legal scholar about whether or not that could happen after you've had hundreds upon thousands of cases that have established this precedent, but I don't think that that's possible at this
All right,
point.
so the problem is that it drives up costs, and we've talked about this
Absolutely.
before. And county legislatures obviously are strapped for cash, all county governments are strapped for cash all over the state, and they've been screaming for mandate relief, and they were supposed to get it part and parcel of the tax cap, and they never did, right? So that was supposed to be the deal, and it never came. The governor's office would say, well, we did do pension reform, but it's going to take a long time to realize that, et cetera. And some of the hard stuff, like scaffold, for example, was not addressed, right?
Well, scaffold shouldn't be hard. It costs billions, it causes injuries, and New York is the only state to have it. The estimate on governments, on the public dollars, are $785 million a year. The estimate on the Tappan Zee Bridge is over $200 million. Just because of this law, a law that again exists nowhere else. And you hear from opponents of reform that, you know, if we do this, New York will be demonstrably less safe. Well, what's happening in other states? They're just as safe, if not more.
So this is an effort that you guys organized then to get the local governments to do this? Because, and the reason why I'm asking is because a lot of activists have turned towards this effort, this sort of strategy. Well, why don't we do bottom-up pressure because we failed so far to convince the powers that be in Albany, and if we exert enough pressure from the bottom up, there's so many patchwork situations that you have to do it. Basically,
Right.
You've got to address it. So is that a strategy of yours?
Well, it started actually organically. It started in Erie County where Buffalo is, and they passed a resolution calling for reform or repeal. They indicated both, due to the costs, due to the impact that this was having on local governments. Once that happened, other counties in the western New York area started to pass similar resolutions, and then it kind of grew out from there. And then we contacted our members and say, go to your local legislatures and talk to them about this. Show them the facts, show them the figures, show how New York is the only place to have this. And once they started doing that, then, you know, here we are now with more than half of the counties having passed reform.
So you will then subsequently, but the county, I mean, the county effort can't supersede state law.
Right. They've passed resolutions in favor of reform. They haven't passed the reform itself. And
So-
they can't do that. They're frustrated with Albany.
No, I understand.
They see in action.
So is everyone.
Yeah, and they see there's so much trial lawyer money, and I've talked about this before on this program, how much money, political action money, is going to state legislators, and that's really stymieing the reform.
So
and
will-
they make money from the Scaffold Law lawsuits, and then they bring that back
Yeah.
to the Albany politicians in
Will
the
this be
form
part
of
of
contributions.
your lobbying effort then? I mean, when you, every year, you know, every organization retools and says, okay, well now how can we bring a new message and new pressure and try and get our issue moved in Albany? I mean, is this going to be part of your strategy coming up in 2016? Guys, like here we have all of these local governments. Will you bring local officials up to have conversations and make them part of the campaign?
I think they're already doing that. I mean, we have, I believe, over 80 organizations that have come out for reform. We've got the School Boards Association, we've got the Farm Bureau, we've got the Affordable Housing Advocates. We've got so many different groups. There's so many ways to do this, and we feel that if we push them all at once, that's really our best strategy, because there are so many angles. There's the public cost. There's the fact that it seems to cause injuries. There's so many different things here, and we can kind of push them all at once.
So one of the things that was a bottleneck was the fact that Shelley Silver was speaker.
Right.
And Shelley Silver was himself a trial lawyer, though he didn't do much actual courtroom work, as we know now.
Allegedly, according to the federal
Right. So
complaint.
we're waiting, and we're going to talk about his corruption trial in a second. But you know, now that he was gone, and after he was gone, actually, you and I had a conversation, and there was this hope that perhaps you would see more movement, or
Sure.
and people being more amenable to your cause in the chamber. That said, you didn't get there this past session.
Well, not much of anything got there.
Well, no,
last
that's
session.
true. But that said,
Because there was some problems in the Senate you might have heard about.
yes, yeah, I do remember that too. But Carl Hastie, who's the new speaker, has a very close friend of his who represents the trial lawyers, if I'm not mistaken,
Yeah.
is a lobbyist. And so, you know, you again have this sort of personal connection to the speaker, although in this case once removed. I mean, are you not concerned about that?
Well, no, I think we have so many different groups. We have so many different impacts, and this is really affecting the public coffers as well. So when the legislature and the governor looks at their budget for 2016, and they know that $785 million is going to a law that only exists in New York and doesn't seem to prevent any injuries at all, and seems to in fact cause them, they're going to look at that and they're going to say, well, we'd like to have that $785 million and spend it on something else. Spending on more affordable housing, spend it on more jobs, spend it on more schools. There's so many options and so many ways that they could use that money.
So speaking of Shelley Silver, when you come in, I like to sort of get an update on what's going on with the asbestos cases.
Oh,
Now,
sure.
part of his corruption allegations, or the charges lodged against him, is that he had a pet doctor, if you will, who dealt with, I mean, a guy who was close to him, who dealt with asbestos-related cancers, and gave that guy state money to do research. He's no longer actually doing the research, he's no longer with the hospital where he was working.
And
but
he's suing the hospital for wrongful
yes,
termination?
It's a mess, actually. But so he would then subsequently refer those patients who then wanted to sue because of their asbestos-related illness
Right.
to Shelley Silver's firm, and there was a fee
Right,
involved,
and
et
Silver
cetera.
would collect a little on the...
Right, the firm and Silver, et cetera.
Right.
So the thing is that these asbestos cases were all sort of in the courts, and these very large settlements were being given to people, except then after his corruption trial, or his corruption case, and now the trial is going to start in November, we saw at least one of those very large settlements reduced
Right.
at least by half, if I'm
Oh
not
yeah,
mistaken.
it was, I believe, 160 million, went down to 30 million. We also saw, you know, it came out that Whites and Luxembourg, Sheldon Silver's firm, was getting preferential treatment to the courts and to the juries. And, you know, once the public scrutiny came about, the courts ended that practice. And I think most regular people are shocked to find that a politically connected law firm could get that kind of special access to our courts.
So now there's a little bit of a new development. Shelley Silver has a very good friend, Jonathan Littman, who's the chief judge of the state, and I should say, just to disclose, conducted my marriage. He's,
Okay.
just so people know, he, it was 2 years ago, he is about to retire. He's
Yes.
forced to retire because he's reaching the mandatory retirement age of 70 years old at the
Right.
end of the year. There are cases pending before him or pending in his court system.
Correct.
And actually those cases have been now delayed.
Yeah, there's 3 cases that were set for November, and they've now been delayed till 2016. And the timing is very interesting because, as you said, Sheldon Silver's corruption trial is going to start in November. And so there's going to be a white-hot light going on the asbestos litigation, on asbestos specifically in New York. And that was at the same time that the court was going to take up these asbestos cases.
But not the
at
Court of Appeals. Oh, yes, the Court of Appeals.
Oh, these are Court of Appeals cases.
Got
Three
it.
of them, Dummett and Constantine. They deal with consolidation. One of them actually deals with, should a manufacturer be liable for a product they neither manufactured or sold? And it's amazing we have to even have that discussion, and obviously we feel that they shouldn't be liable. But those were cases that were going to go up in front of the court, and now they've been kind of suspiciously delayed, perhaps because of Silver's trial starting, and also perhaps because of Jonathan Littman's connection to Silver. And you know, the court may be in a very, very difficult position if the chief judge had to recuse themselves for a conflict of interest. And I think they didn't want anything to do with that, and so they moved it to 2016.
So just very quickly, I mean, there's been a call from the business community. There's going to be 2 vacancies on the Court of Appeals,
right.
And now former Chief Judge Judith Kaye is leading the search to make recommendations to the governor to fill those vacancies, and we'll have to have a new chief judge, of course. And the business community would like to see someone with business acumen appointed to the bench, because they've lost almost everyone. I believe there's only one Pataki appointee left on the bench, if I'm not mistaken. And is that something you agree with, that there should be someone with a business mind on the court
Sure, and let's not hope that that business was just suing people. I mean, we'd like to see somebody with a broader perspective. You know, sometimes the law does such crazy things that regular lay people don't even understand how you know, somebody could be liable for a trespasser's injuries, for example. And so giving somebody with a perspective outside the law, I think would be greatly helpful to the court.
Well, obviously we'll be following that, and we thank you so much for coming in. And
it's always great to be here.
And talking to us about all manner of things. So after the break, 400 high school and college students will be flocking to Syracuse tomorrow, and we'll tell you why that is next.